All right, well, welcome everybody to the third installment of our Iqua Coffee Talk series, where we will be discussing the Iqua Notice of Child Placement Proceedings. Just to follow up with you on a couple of details, we do have the previous sessions recorded, and we are reviewing them as a panelists right now. And hopefully we'll be able to get those posted for viewing by other county and child welfare partnerships out there in the state of Minnesota. I have another question already in the Q&A. Was this handout sent to participants in advance? Again, if you go to the SSIS resource page under the training side on the right-hand corner, and I can show this again later after we get done with our presentation, you'll find a list of previous Coffee Talk series, and the information that we are going to be talking about today in this presentation is also listed in PowerPoints of the past as well. So I'm going to go ahead and throw that link into the chat for you to the SSIS online resources and webinars page. So without further ado, I'll introduce myself. My name is Kratt, and I'm the SSIS training lead, and I'm a liaison between the Child Safety and Permanency and the Minnesota Child Welfare Training Academy, and I have a lot of other famous panelists with us today. And I'll hand it over to Sommer to introduce herself, and then she can pass the baton from there. Welcome, everybody.
Yes, welcome, welcome. Good morning. My name is Sommer Rosette. I'm a member of the Chippewa Cree tribe of Rocky Boy, Montana. I'm an SSIS Iqua training consultant, and I've been with DHS for roughly 8 years. So I'm excited that we're here today with everyone, and I'll go ahead and pass on introductions over to the next person, and that's Richie Smith.
All right, Bonjour, this is Richie with DHS, Equal Compliance Consultant. Been there for like 2.5 years, something like that. I'm also, did I say I was Leech Lake band member? Well, if I didn't, I'll say it again. Leech Lake band member. And the thing I always like to stress is that tribes, they have kids, they have dual citizenship. It's not race-based, equal laws and stuff like that. So just always remember that it's not race-based. They have dual citizenship. The tribes are sovereign nations. They have their own governments. And the famous thing I like to say is the children and the tribes are interwoven. That's the best interest of the Indian child. And without no children, there are no tribes. Miigwech. I don't know who's next after that.
Well, go ahead.
Oh,
go ahead, Carrie.
Good morning. Good morning, everybody. Welcome to Pajuta Sapa time, which means coffee in the Dakota language. It means Black medicine. It's good to be here today. I live in Tewinda, which is the Prairie Island Indian community. I'm an enrolled member of the Omaha tribe of Nebraska. My name is Ishtama Zewi, Iron Eyes Woman. My English name is Carrie. I've been at DHS for about 2.5 years. Prior to that, in child protection. And again, good morning to each and every one of you.
Cindi?
Good morning, everyone. My name is Cindi Miller. I'm a compliance consultant with DHS. I've been working there since July of 2018. I'm also an enrolled member of the Lower Sioux community in southwestern Minnesota. Reanna?
Good morning, all. Reanna Jacobs, the Iqua Supervisor at DHS. I've been with DHS for about 5 years now, and I'm also a member with the Lower Sioux Indian community. So good to see so many have joined us today.
Yes, welcome everybody. So good morning, and again, welcome to the Iqua Coffee Talk on Iqua Notice today. Iqua Notice of Child Placement Proceedings. If anybody has an issue with their resolution of their screen, they're up in the top right corner of your screen, you can adjust your resolution. This is just a quick snapshot of our agenda today. So we have already gone through our panelist introductions and pronouns. We'll go through some participant instructions, go through a brief PowerPoint presentation, and then we'll get into the Q&A. So really quick about participant instructions. We ask that everybody please use the Q&A feature to send in your questions. And not the chat feature. It's solely because it's easier for us to keep a digest of the questions coming in and the ones that are answered during the coffee talk today. So we'll go ahead and just kind of go into the PowerPoint presentation, and then we'll get into the Q&A. So the first thing I want to go through, and this is something that we show in most of the Iqua coffee talks, it's because it's extremely important when we're working, or when you're working with tribes, to involve the tribes to be part of the assessment and investigation. You want to involve them as early as possible. And we want them to, potentially participate in the first face-to-face visit. It's an important component of active efforts, and establishing that working relationship with the tribe from the beginning of a case can potentially lead to better outcomes for American Indian children and families. The number one goal that we want you guys to have is for family preservation. Another Iqua notice requirement, local social service agencies are required to send Iqua notice by registered. And I'm going to say that again, you're required to send Iqua notice by registered or certified mail return receipt at least 10 days prior to the admit deny hearing on a CHIPS petition and a TPR petition. We get a lot of questions about the certified mail, so I think it was important to point that out. The other thing that I wanted to point out is just another it's a resource. It's the Iqua Mifpa desk aid. I'm showing just a small screenshot here because I wanted to point out the EPC hearing and how this flow chart can help you through the case when you're working with Indian children, and when to what your next steps are when you have ongoing case management and what happens within the first 72 hours. If you don't have access to this, this is found on the DHS website on Edocs. If you're not using this as a resource, you can find it on Edocs and print it out and keep it at your desk. It's an amazing desk reference, and it helps you through the flow of the case. This is just a quick snapshot of the actual Iqua notice on Edocs. They are available on Edocs solely because some people don't have access to SSIS, like the licensed social, or excuse me, licensed, help me out here. The other areas that don't have access to SSIS, the adoption agencies.
Private agencies.
They don't have access to SSIS. But what's important about the Iqua notice is it needs to be sent along with a copy of the genogram. And that also is a document you can get on Edocs, but it's also found in SSIS. Just a couple other things to remember when sending out the Iqua notice of child placement proceedings. You need to send to the Indian child's parent or parents, the custodians if there is one, as well as the tribe or tribes if there are multiple. You also need to send a copy to the copy of the notice that was sent to the Midwest Regional Director of the Bureau of Indian Affairs. This notice must be filed with the court, and each return receipt must also be filed with the court. And what I'm referring to when I say return receipt, I'm just going to show you quick snapshots of those as well. Oops, sorry. This is when it's sent out. This is what the Postal Service certified mail receipt looks like. And then when you get that return receipt, which is sometimes referenced as the green card, and those on the panel, you can chime in at any time regarding this, because this is an important component of the Iqua notice. This is what the green card looks like. So the sender would complete this top section here, as well as print your name and address and zip code here. And this here is where the individual receiving the information would sign and print their name and the date that they received that. So these components are all important as well. I realize, you know, that this is what the postal worker receives as far as the signature goes.
Yeah. And then Sommer, one question, just one thing here, and this is when we're doing our reviews, this is the main thing what we're looking for when we're looking through reviews. If you get an audit, we're looking for these green cards, and it needs to be signed, that number A up there is signed, and then it needs to be dated too. And sometimes when we see problems like for some reason it didn't get signed, sometimes you can, if the court can stamp it, and if it's 10 days prior to the out-of-home placement, you're good. If not, there's a receipt. When you purchase this certificate, there's a receipt. You can go online to see when it was signed and dated. So just keep that in mind. So there's a receipt when you purchase this. You can go online to see when it was dated and stuff like that. Because sometimes they don't date them. I mean, I wish they would sometimes. I don't know why it happens, but that's just ways to figure it out. So you guys are in compliance with during the reviews.
Thanks, Richie. Again, as I mentioned, you need a copy of the genogram also needs to go with the ICWA notice. So I just provided a quick snapshot, and again, the ways that you can access these on Edocs. The other one that I have here is called the supplement to the ICWA notice, the child placement proceedings. This is something you would use when there's more than 4 tribes identified. So it's just something I wanted to provide as a reference.
And that's a lot of ICWA notices, we get it, but we're looking for hits. Every one of those tribes need to be notified because they could have lineage to a family member or someone that could be a possible placement. So you need to do that. And even if you know that that person is enrolled into a certain tribe like Leech Lake, and they have affiliations to White Earth or Laura Sioux, those ICWA notices would still need to go out and sent to those tribes.
Thanks, Richie. This next screenshot is just something on, it's on page 3 of the ICWA notice. When you're submitting this to the BIA, if you're just sending it as a copy and you don't need any assistance with trying to identify whether the parents, trying to find the parent's address or any information the BIA may have on those parents, there's a checkbox that says no assistance needed. So you would make sure and check that when you send that copy to the BIA. But if you are needing assistance with identifying tribal affiliation or unknown parent's identity and or address, you would check the the second box on page 3. If anybody on the panel wants to provide any additional information regarding that section, you can. All right, so now that we know the paper form of the ICWA notice, we're going to move into the requirements in SSIS. So the initial thing that you need to make sure that you're doing in SSIS is you have to complete the race screen. This is what kind of triggers the ICWA, or excuse me, triggers that there is an American Indian, either eligibility for enrollment, lineage, and from the race screen, you can go right to the ICWA folder. Once you get to the ICWA folder, you need to create a new eligibility determination. Once that information is created, you'll get your data screen. And by this point in an ICWA case, you should have already completed, your status inquiry, all those tabs that are within the new eligibility determination or that ICWA eligibility. And the fourth tab is where you would complete the information for the ICWA notice. And this is the ICWA applies and determination. Right here is where you would let them know whether or not ICWA applied and if you had received any notification from the tribe. Anything anybody would like to add? Okay. And then once that information is sent to the tribe and you receive information back under the child custody proceeding notifications, you would select new child custody proceeding notifications by right-clicking on the tree view. Once you select new child custody proceeding notification, you need to document that you've received that the tribe has received those specific the ICWA notice that you had sent out and the information that you got back from the tribes. So you would document when you sent that information in the custody proceeding notification, as well as the green card when you received it back, when the notice, where it says notice received date. And the next thing that I'm going to show you is in Chronology. This is where you can find the ICWA notice. Oops. Oh, those are questions coming in, sorry.
Yeah,
It blocked
questions
my
coming
screen.
in.
Yeah, on chat. We'll get to your questions shortly. If you can please use the Q&A feature for your questions and not the chat feature, we'd really appreciate it. So under chronology, you want to right click and select new document. You'll get your search option on the data screen that moves to the right, that opens to the right, and you can select the search option. Once you select the search option, you're going to be given an option for group type and category. It needs to list state, and the category needs to be placement-Iqua. Then once that, you'll get all of those that come up, or excuse me, you'll get all the documents that come up under placement/Iqua, and the one that you want to select is the Iqua Notice of Child Placement Proceedings. Once you click on the document, it'll like highlight in blue, and you come to the bottom right and you hit select, and that'll open up the document setup for you. And so in the document setup, you need to go through that document and fill in the appropriate selections from each drop-down menu of each part of that document setup screen, excuse me. And then you'll be able to kind of take a look at what that document looks like before you send it out by using the document editor. And to do that, if you look here in the top left-hand side, you'll have that setup screen that you were initially on, and then the document screen. Once you select document, the little E under the left-hand side, you'll get the document editor, and you'll have an additional screen that opens up, and it will have the Indian Child Welfare Act Notice of Child Placement Proceedings document, and you can go through and kind of look at it before sending it out. My screen just literally, can you guys still see me sharing my screen?
Yep.
Yes,
I can see it.
I
Okay.
can see your desktop.
Yeah, I'm trying. I don't
Now
know
we're on your
what
desktop.
happened. Let me just pause.
Can you
sharing.
stop sharing for a second?
there we
and then
go.
Oh,
Go ahead.
I was wondering if I could just share something really quick about how to find Iqua related documents in Edocs online.
Sure.
I should just type in Iqua and it pops out.
I'm not
So-
sharing. You can go ahead.
Okay, can you see my screen now?
No,
You probably can't see my screen.
I think it's starting to.
There you go.
All right, so we are on the Minnesota Department of Human Services Edocs page. Once you are there, you can type Iqua into the search field here and then select search. And I have a task bar here that I'm just going to move out of my way. And then you have several different Iqua forms to choose from. You have the non-compliance complaint form, grantee quarterly report, and then you'll find the Iqua Notice of Child Placement Proceedings here as well. And somebody had asked what the Edocs number was, and that's DHS 5227C-ENG. You'll find your fillable Mifpa notice here as well. And then the supplemental Iqua notice that Sommer Day was referring to is also found on this page. However, if you have access to SSIS, best practice would be to fill out the Iqua notice in SSIS. Okay, back to you, Sommer.
Cool.
All right, thanks, Eric. I appreciate that. And that was the end of the presentation. We can actually get into our Q&A now. So
Right.
let's go ahead and pull up our first question. All right. What do you do when you get back from the post office and they aren't signed or dated? There's just a scribble on there. I guess they're asking, how do you document that, or what do you put in for the date if it's not there?
Well, we're really asking that a good best practice would be, when the counties get that in, usually someone will stamp it with a date, and we can kind of use that too. But I think Richie talked about, once this is a service that you purchase, once you once you purchase that service, if there's, you could punch the numbers in on the certified receipt, and sometimes it'll pop up the date that it was given to the tribe or whoever signed it, and you can use that date. Yeah, because we realize this is something that happens. I guess at least a quarter of the time we find that this happens, and when we're looking for the date. I don't know if you want to add anything, Richie.
I mean, just like you said, just document that this is what happened, and that when you purchase that receipt, you can go online and see when it was, when they received it. So you can make a copy of that and put that in your documents too, and go in that route. That's the best route, that the tribe did receive it, so they know. For tribes.
Thank you. So the next question that we have is, can the green mail card be scanned and kept electronically, or do we need to keep the physical card?
That depends on your county. I think that's something you need to talk with your supervisor about, or, I mean, you guys will determine how you're going to do it. But when we're doing our reviews, we're looking for those certified copies in MGA. So people upload them in there, and that's where we're finding most of the signed green receipts.
Yeah, we love MGA. That's the best one to find it. So if you can do it, I'd put it in there. Or SSIS, but MGA is the best.
Okay, thank you. Next question. If we don't get a response from the tribe or the BIA, which we usually don't, do we just leave it blank? So
I am not sure about this question. If you're sending out certified receipt or registered mail, they're going to sign it and send it back. I don't know if you're confusing this with the Mifpa notice,
Right.
or I'm not sure. So it's hard to answer that question.
Yeah, because the BIA for sure would sign it. Sorry.
Yeah, you cannot have the admit deny hearing if you don't get the response, the written receipt back from the tribe or BIA.
Yeah, and if you didn't get the response back, maybe you need to send it out again. Show your due diligence that you are reaching out to these tribes, or the BIA. I mean, the BIA will sign and date it. That's one of they're there. All of this federal government is there, so one of the main things. But if they're like, I guess, Carrie, like if they sent it out, to the tribe, maybe it's a South Dakota tribe or something out there, and where they have a post box, you'd send it again, maybe to show your due diligence that you are reaching out and that you're trying. You need to show due diligence that you are trying to contact the tribe in that way too, for the tribe, at least, anyways. Just like a parent, I guess.
thank you. Next question is, and I think you just kind of answered this one, but I'll say it anyways. Does the notice to the BIA need to be sent by certified mail also?
Yes. Always certified mail, those green cards.
Thank you. When will we be receiving responses? Oh, sorry. What if we do not get a response from the tribe, but we know from another state that they received a response that the child is Iqua eligible? Do we wait for the tribe to respond and put pending, or do we put Iqua eligible?
Well, if you have reason to believe, first of all, then it is Iqua. It is an Iqua case. So that part is easy to answer. As far as not receiving, we just kind of talked about that. If you're not receiving the signed green card back from the tribe, then you would attempt to send it again, or check your address. Make sure you're sending it to the right address, because the certified mail goes through the postal service. The postman delivers it to the tribe, and either somebody will sign it there. I mean, so I don't, and you would just have to, I know we've heard some isolated cases during COVID that maybe they aren't in the office physically, but those are pretty rare cases we're finding out. We don't hear about that a lot, but like Richie said, you would be documenting everything that you're doing as far as trying to get that, sending that certified receipt out to the tribe and when it came back and when you sent it again, you're documenting all of that in SSIS chronology.
And Carrie, you remind me of the Federal Register BIA. That's the designated tribal agent. That's the address that you need to send it to. There can't be other addresses that you send that to, because then you might not get that information back. So always go to the Federal Register BIA and look up that address and who is the designated tribal agent, send that information to. That's one of the most important things, that everyone should have, that Federal Register BIA. I know Eric's covered it. We have one electronic version where you just type in the tribe's name and it kicks it out and kind of goes that route. So keep that in mind. Always check to see if you're sending it to the right place.
Thank you. So the next question I'm a little bit confused by, but I'm gonna read it. When we are completing an Iqua notice, is it also required we complete the Mifpa notice?
Yes.
Well, there's
But
two
you
separate
always should-
notices we're
go ahead.
talking about here.
Yes.
The Mifpa notice needs to go out immediately. We talked about this at our last coffee talk, but the Mifpa notice needs to go out within 24 hours of any screen child assessment or investigation. So that would go out way before the Iqua notice. Once the case goes to court or there's an out-of-home placement is when you would, prior or the admit deny hearing, that's when you would send out the Iqua notice. So both are required. One is just sooner.
Yeah. And I just wanted to add in there, Carrie, the Mifpa notice is not sent certified mail. I just
Right.
want to throw that out there. We've had many counties reaching out saying, we send the certified mail. Well, no, you do not send the Mifpa notice certified mail. It's the phone, it's a call, or the fax. So keep that in mind. Iqua notice is a federal notice that we send off to the parents, the tribe or tribes in the BIA, or any custodian.
This is Reanna. I would also add the difference between the Mifpa notice and Iqua notice, where Richie just mentioned the Iqua notice goes to the parents, Indian custodian, and the tribes, and a copy is sent to the BIA. The Mifpa is only provided tribe into tribe.
Thank you.
And one more thing to throw in there, when we send out those Iqua notices, and let's say you're working with a couple that's they're married, they're living at the same address, you send 2 Iqua notices to that same address. It cannot be just one Iqua notice. We've had a couple of counties do that happen that before, so I just wanted to share that with you. You have to still send 2 Iqua notices.
Okay, so this next question is rather long. So if you
Love it.
sent, so if you sent out the Mifpa at the beginning of a child's mental health case and found out a child is a member or eligible for membership, however, you've been open and not involved with anyone from the tribe because it's a voluntary case and there's no placement. But then the child goes into a voluntary residential treatment facility. Then do we need to send an Iqua notice recognizing that they went into residential? Because Mifpa is the required document for just letting them know a case is opened, but Iqua is what is required if a placement happens. But is there a distinguishing point between residential placement and foster care?
Well, if it's truly voluntary, you don't have to send Iqua notice out. If it's truly voluntary, but if you're saying, okay, this child needs to go here, else we're going to have to have child protection, or we'll have to do something, then that's not voluntary. So then Iqua notice would go out then. So it's kind of a, there's lots of things in there we could talk about in there. It's going to get kind of complicated.
So I would say if this is a voluntary case, Iqua provisions do apply. You don't have to send the Iqua notice. However, active efforts to engage the tribe is a requirement because you really want to be following placement preferences when you're placing this child into a voluntary placement. You're really wanting to have that conversation with the tribe about what's in the best interest of the child with regards to cultural connections, with keeping them in line with what the child needs. So I would say what Richie said, that it can be a complicated question, but in the interest of the child's best interest, ICWA provisions apply even prior to the placement of the child. Active efforts are required, engaging the tribe are required. So, and then the tribe determines their level of involvement. If the tribe is saying, well, we can't be at every single, face-to-face meeting with the child, we can't be as involved as we would like to be, you're still, as an agency, required to engage the tribe.
And I would like to add on to that, that even if the tribe doesn't get back to you and say, you know what, I can't be involved, it's still active efforts would include that you send an update to the tribe via email, mail, whatever it is, updating the tribe on how the child is doing. That is a part of active efforts.
That's exactly what I was going to say. Thank you, Carrie.
Okay, so the next question is, just to clarify, I'm still waiting for the other state CPS to get me the information, but if they do not send me documentation from the tribe, can I go ahead and mark it as ICWA eligible?
If you have reason to believe that a child is Indian, then the case is ICWA eligible.
Next
it's ICWA
question,
eligible.
Reanna. Oh, go ahead, Richie.
Until you get a determination letter from the tribe stating that. So, I mean, and that's what we're talking about, active efforts. Sometimes you need to think outside the box. If they're in state, maybe go out and try to reach out to this tribe, go meet up with them. Many times I went up to tribes and I spoke with them, get information, and develop that relationship. So that's just some ideas how you can go to get the information so that you're just like hanging out there for months. I mean, I know we've had a county that needed something signed by the tribe and they kept calling and no one answered. So I took the information, I went up to that tribe and we got it done. So sometimes you got to think about like just going out there and setting up meetings and kind of going out there and then we get some of the things figured out. So it's active efforts, thinking outside the boxes. That's helpful. And you develop relationships. So it's a good thing to have.
Thanks, Richie. Next question, with Mifpa, Equinox Notice and Genogram, can the county create their own forms and letters as long as they have all the info instead of using the DHS forms? The Genogram is not viewer friendly.
We don't require it, but I know if some counties, like if they do that, I know there's some counties that are not getting full 100% from Mifpa Notice because they're not doing like the phone call or the email or fax one. They're messing up on one of them. So it's best practice to follow the DHS. I mean, I would do that, but just letting you know so you get 100% compliant because it's 100% compliance now. So you want to make sure you have all your things in there before you decide to do your own. So you don't want. Anyone else have that? I don't know. I see Reanna.
I just want to add on that the genogram was developed to ensure that all the state statute and federal law was documented in the right way in those genograms. And I know it's not like a genogram where, it's not user friendly, as you said, but when you use that form, you're ensuring that you're following all of the Iqua and Mifpa requirements.
And I would just add the purpose behind the genogram is also for the tribes to make an informed decision. They base, some of times their eligibility criteria and membership from, familial connections. And as much information as you can provide really helps the tribes to make an informed decision about that eligibility as well as membership.
Thank you. Next question. If you do the documents outside of SSIS and attach them in SSIS and document it, you also need to put hard copies in the file, or is attaching the documents in SSIS enough?
Well, again, that's something that you would have to really talk with your supervisor about on how they want, the county wants it done. We don't dictate how that needs to be done. What we're looking for is documents. So we're looking in SSIS, and that's great for us if we find those documents in SSIS. As far as the hard copies, that's something you'd have to go to your own county to ask how they want that done.
Thank you. Next question. I also see that lately the post office, instead of asking for a signature there, it's documented COVID. What can we do for that on the green card?
As we stated earlier, making sure you're documenting that. You know, we are affected by this pandemic, tribes, counties, everyone. So at this point, I would just really emphasize documenting that in SSIS so that we can see that.
Thank you. Next question. Is the CHIPS for protective supervision without out-of-home placement considered a child placement proceeding?
Can you repeat that,
Yeah,
please?
yeah.
Sure. Is a CHIPS for protective supervision without out-of-home placement considered a child placement proceeding?
No, if they're in a CHIPS for protective supervision and you're working with the family and offering services, but the children are not in out-of-home placement, it is not considered a child placement proceeding.
But are they in court and stuff? But is it
Yeah.
potentially that these child could be placed out? It just depends. Well, if the mom has something, or I don't know. There's always potential. So I don't know.
So I would say best practice is that you're having these conversations with the tribes so that they can participate. For sure, the Mifpa notice would have kind of brought the issue to their attention, but a part of active efforts is that ongoing back and forth communication. And if you're going to court and you're asking for protective supervision, it would be really best practice to notify them in some way. It's not a requirement. However, you are required to have that conversation through active efforts and consulting with the tribe, as well as communicating what's going on with the family.
All right, thank you. Next question. What are you suggesting counties to do with the green cards for cases that are not involved in court, since they are only getting filed in MGA on those cases? You need me to repeat that one?
Yeah.
Yes.
What are you suggesting counties do with the green cards for cases that are not involved in court, since they are only getting filed in MGA on those cases?
I am not understanding
Yeah.
that.
I don't understand that
Yeah.
because the cases that you need to send, that you get the green cards for are cases that are in, foster
court.
home placement or TPRs. So
Yeah.
they would be in
Child
court.
custody proceedings.
Yes, they would be in court.
You wouldn't need to send out an Iqua notice if they were not in court or going to out-of-home placement.
Right.
Maybe that helps clarify. I'm not sure, but if there's more to that question that we don't get, then just send it in. Thank you.
Yeah.
Thank you. Next question. For admit deny hearing, do we need to send out notices for every admit deny? For example, the admit deny was held and then continued or pushed back due to offender not having an attorney. Do we send out notices again?
Well,
You don't have to send out a notice if the admit deny was continued. A lot of times the court will continue the admit deny hearing because people were not served.
right.
So they'll just continue it for another, whatever, 2 or 3 weeks. So you don't have to send out another Iqua notice for that.
And that's usually why the admit deny is not why they're continuing the admit deny, because you didn't get the return receipts from mom, dad, tribes, or the BIA. So you need all those return receipts in before you can continue past that admit deny hearing. else you'll be found out of compliance.
All right, thank you. Next question. If we have an adoption that was done through the tribe, so the bio parents' rights were suspended, the children who were adopted were placed on a hold and now a CHIPS. What is our responsibility to notify by certified mail to the is it our responsibility to notify by certified mail to the biological parents? We have sent to the legal guardian who adopted the child and to the tribe and BIA.
It's good discussion, but it says like the ICWA notice needs to be sent to the bio parent. So that's kind of one thing. I don't know if Cindi or Carrie want to chime in there, but the ICWA notice, I mean, because let's look at what if this legal guardian or they're not able to take care of these children. Well, maybe these, what's wrong with getting the ICWA notice to the bio parents? Maybe they are in the right place to take care of these children or not, but the county will decide that, Rob. You're not hurrying by saying the ICWA notice to a bio parent. If you guys have jurisdiction. I mean, you said tribal court, so I don't know the whole spiel on that, but.
Wait, was that in tribal court? Is that what that was said? Tribal court?
You said part of tribal court.
Says that the adoption was done through the tribe, so the bio parents' rights were suspended.
Okay.
Okay, thank you. Next question. Sometimes the parents do not sign the receipt or get their mail or they keep moving different addresses. Any suggestions?
Yeah, occasionally we see that happen. And so we just recommend again that you document that in SSIS. And you're gonna, the return receipt is going to be filed in MGA that it was not signed. And then you send it out again, and then another one comes back not signed. You're going to be putting that in MGA too. So you're leaving a paper trail of everything that happened and documenting that you did your due diligence to try to get these forms to the parents.
I think sometimes when we're looking at in MGA, we'll see like an envelope that has a couple of dates crossed out on it that somebody was. I tried to serve somebody 2 or 3 times, and they were unable to serve them, but that's showing due diligence that the agency did send a notice out at least a couple times.
Right.
To show to the court that they've done their diligence.
Yeah. I got an example of due diligence when I was working out of Hennepin County. I mean, I don't know if our Hennepin County attorney is listening right now, but anyways, the man had got deported back to Mexico. And so what our county attorney did, she contacted the consulate in Mexico, and they were able to locate this father. So the green card was delivered to him. So that's due diligence, and that's active efforts. That's reaching out, thinking outside the box, saying, and this man was able to, get a legal status. So he got notified that his child was in a child custody proceeding. So just something to think about if they get deported, maybe contact the consulate. You might hit a hit.
Okay. Next question. Thank you, guys. How long should we wait until we send another notice to the tribe again via certified mail?
Send it out right away because you want to get that mid-tonight hearing going. I mean, I would look up information,
Yeah.
I
think I would attempt to contact them, to see if maybe there's people are only there certain days of the week to sign or something like that. Try to communicate with them some other way before you send it out again. If you're just sending it out to the same address, a couple days later, that might not be the answer. Try to call them and find out what's going on, or if it's a Minnesota tribe, maybe you can get somebody from the American Indian Center who are the liaisons with some of the tribes locally to help out, because we're in a COVID time, so who knows if they're there every day of the week. Most of them aren't.
Yeah, the Minneapolis American Indian Center, they work with the out-of-state tribes, so mainly North Dakota, South Dakota, Wisconsin, and they have other contracts too, but that's a good intel to if you're trying to get information, or they have their foot in the door already, so you can talk to them and they can talk to that travel rep. Minneapolis American Indian Center. Phone number 612-879-1700. Contact person Laura Newton.
612, can you repeat that?
879-1700.
Oh, shoot, I should have put. Okay, next question. Thank you. Does the CPI just do Iqua notices? I assume that's the only part of the question. Does the CPI just do the Iqua notices? This must be agency specific, or what is?
I don't know what's CPI.
What is CPI?
I'm glad you asked
Child
that.
protection investigator, I think.
I think, but I mean, we don't know. So I don't think we can answer that. So
How long, wait, no, next one is, what is the electronic BIA search thing that Richard was talking about? That would be so helpful.
It's on there. I know, Eric, you had a we had one out there, but it's the Federal Register BIA, and when you have when you look on there, if you have that link, you click on there and you'll see it. I don't have to show it to you right now. I'm sorry, but there's a link in there, and you click that, and it is helpful. It goes right to that tribe and stuff like that.
I'll see if I can find it.
Okay, thanks, Eric.
So you can go to the BIA website and then put in the search bar Iqua, and they have an interactive map. That's what Richie is referring to.
Yeah, there's like 3 BIA things there. One's PDF form, which is updated once a year. The other one is, it's updated once a year, but it's electronic, go down. But you hit that one website where Eric will show you. It's updated every 4 months.
I think Shad beat me to the punch. He put a link in the, Shad Cook put a link in the
Oh,
chat.
wow. There you go, Chad.
So Shad is our honorary panelist today.
Right.
Thank you, Shad.
All right, so a couple of questions not related to, for the questions that are not related to Iqua notice, if we have time at the end, we'll come back to those.
I do want to answer the one where it says if we learn about possible Native American heritage later on in a case, not in the
Okay.
investigation, do we do a Mifpa notice at that point? Absolutely. The moment you find out that that a child that has American Indian heritage, you send that notice out. You're required to send that notice out. Okay, so go ahead. That was easy. So move on.
I only do voluntary placements, so I do not need to do the Iqua notice for those cases. Does the voluntary placement agreement still need to be signed in front of a judge?
It absolutely does have to be signed in front of a judge. And again, to reiterate what we said earlier, active efforts need to be happening too. So you need to be contacting the tribe, working with the tribe on, case plans, on any kind of cultural resources they might have. If they're not active on it, you still have an obligation to send out emails or letters to the tribe, letting them know how the family is doing.
Okay, thank you. Next question. What if your client identifies with a Canadian tribe? Do we provide them notices as well?
Best practice would be, yeah, why don't you? I mean, they might have resources available for the family. They might, you might be able to connect the family with their tribe, but legally, you do not have to send out a Mifpa notice or Iqua. It's only for federally recognized tribes.
I would say in terms of this, you're really honoring the spirit of Iqua, which is the intent.
Right, especially if you're located near a Canadian border, that would even make more sense. It would be best practice to get in communication with their tribe to see what's available and to see if they can assist in any way.
Yeah, especially for family. They'd have the information for family and stuff. So it would be best practice trying to find something.
Thank you. Next question. If we send a Mifpa and the tribe states that the children are not enrolled or eligible, are we still required to send the Iqua notice if the children are later placed in foster care?
If you get something written from the tribe saying that these kids are not eligible for membership or enrollment, then it would not be an Iqua case if you have that documentation. So no,
It has to be written up.
Yeah, but it has to be written from the tribe. Yep.
All right, thank you. Next question. We've had instances where children have been placed. We've had the EPC and admit deny hearings, and then the parents share that they may have American Indian heritage. Parents have been asked numerous times leading up to this. At this point, we've been sending Iqua notices. Is this correct?
That is correct. As stated earlier, we had a question similar to this about doing a Mifpa notice. So if you found out, I'm trying to go back, sorry, I'm gonna read it. I do better if I can see it. And I just disappeared on me, but.
And sometimes when they answer that, they might not have built that trust up with you guys yet either. You know, sometimes it hasn't been the best thing saying, hey, I'm American Indian, because it didn't work out well for a lot of people. So that's why they keep it down. And so you got to build that trust. And so maybe now you're finding that information out. So just keep that in mind. That's some of the reasons why you always inquire right away in the beginning, especially during a family assessment or family investigation. We want to know if these children have any tribal affiliation. And keep asking, build that trust up.
I hope we answered that. You would definitely have to send that Mifpa notice out right away. I can't find the question. Who was that question from?
Kelly.
Okay, we can just move on.
Here, you want me to read it again?
Sure, why not?
Yeah.
Okay. We've had instances where children have been placed. We've had the EPC and admit deny hearings, and then parents share that they may have American Indian heritage. Parents have been asked numerous times leading up to this. At this point, we've been sending Iqua notices. Is this correct?
Well, that's correct. You would send out an Iqua notice, but you would also send out the Mifpa notice, and that's really important too. As we stated, once you find out the child has American Indian heritage, it's required to send that Mifpa notice. So you're going to be emailing and faxing them and then calling them on the phone saying, hey, we're here in the case, and we just found out that despite us doing inquiry, we just found out that the child is a member of this tribe. So we wanted to let you know right away. And then you would be sending out the Iqua notices if court's involved, definitely.
And then one more thing too, once you found out when they said they're Iqua, prior to that, you need to state that you did ask them before you inquired. So you have that as a reference documented, because if you don't have that documented, you will be found out of compliance. So always document you inquired on the date and time for those family members.
Thank you.
As well as the other provisions, you would be doing active efforts, you would begin active efforts. You would again do inquiry with other family members. So you would start that whole process and document that in your SSIS chronology. Okay.
Thank you. Okay, so there's two questions here that are pretty similar, but the first one is, if the Mifpa notice is not certified mail, does it require a tribal response?
The Mifpa notice does not require a response from the tribe, and it doesn't need to go out certified mail. The statute says either fax or email with a phone call.
No certified.
So then there's this next question that says, just to clarify, the Iqua notice and Mifpa notice need to be sent through certified mail. So, yeah, sorry, go ahead.
No.
So I
Only
think we just
Equinox.
answered that. We said MIPA
yeah.
notice needs to be sent out. I mean, sent out by email or fax, and then you make that phone call and document that. So there's no certified mail required for that. It's totally separate notice. And ICWA, again, there you have to send that certified or registered mail 10 days prior, at least 10 days prior to the admit deny hearing.
Thank you. Next question. So please clarify. We need to update the tribe regarding a voluntary placement, even if the tribe has determined they do not want to be involved or the child is not ICWA eligible.
Well, there's two separate
Yeah.
things here. You need to update the tribe regarding a voluntary placement if it's an ICWA case. And it would be an ICWA case if you have reason to believe the child is affiliated to a tribe. Again, if you get something written from the tribe saying the child is not eligible for membership enrollment or tribes, you would have to get it from all of them, then it would not be an ICWA case.
But I
If
think,
the
yeah,
tribe determines they don't want to be involved, but it is an ICWA case and the tribe is not involved, that's fine. That's the tribe can determine their level of involvement. They can become involved at any time throughout the entirety of the case. But sometimes they don't get involved until TPR. Sometimes they get involved when it goes into out-of-home placement. It's all up to the tribe when they want to be involved. However, the onus is still on you to do active efforts and let them know how the child is doing, whether it's through email, mail, phone call, whatever. You still have to ensure that you're reaching out to the tribe.
yeah, even if they're not intervening, keep on to get a letter saying that they're not ICWA eligible.
I just want to acknowledge really quick that it is 11 a.m. and I just want to check in with our panelists. We have 21 questions remaining in the Q&A. Are we comfortable with moving our meeting to 11:30?
I'm fine with that.
Okay.
I mean, I know that some people in the counties can't, cannot stay to participate, but I'm fine with going an extra 30 minutes if they can.
Okay. And this meeting is still being recorded. And I know we get several questions about the recordings and how we're going to deliver them. And we're still making a decision on that right now as we review the previously recorded videos, but we should have them available and posted for viewing. And we'll announce that when we get to it. So we'll continue on with the Q&A until 11:30. See if, or until we have satisfied the Q&A.
Sounds good.
One or the other, 11:30 or before.
Thank you. I was like,
I like that.
Not going to be here all day, folks. Okay, back to you.
Eric will be trying to push it to 12 and 12. No, I'm kidding. Okay. When you have a case in which the parents say they are native but know nothing about the tribe affiliation, what other steps can you take to identify a tribe?
Well, if
We'll
you
try to-
found this out when you opened up a case, you would be obligated to send out the Mifpa notice to the BIA, asking for their assistance. And as you get to know the parents and build a relationship, establish a trusting relationship, then you would start, maybe asking them to talk to other family members to try to get information, really trying to get more information on the tribe that they may be affiliated with. Maybe you come across aunts or grandparents, really trying to make sure that you're doing inquiry with all the other parties of the case.
But if they say that I have tribal affiliation, I don't know what tribe whatsoever, then we go to the BIA requesting for assistance in that route. But if they say something different, like Chippewa, then it goes like Chippewa tribes. Like you work it out. You, like Carrie said, you ask questions, and you try to get more detailed and stuff, and hopefully they'll share more information with you. But if it's just affiliation to American Indian heritage, then you send it to the BIA with as much information you have, so the BIA can hopefully help you out.
Thank you. Next question. Okay, so is there a DHS document that should be used when sending an eligibility letter? I don't know if we probably need more information about this question.
Are they talking about membership or enrollment?
I think that's what they're asking. I'm guessing.
I would assume.
Yeah.
Yeah.
At this time, just does not have a template for that.
What was that, Reanna? You were breaking up.
DHS does not have a certain format this time.
Oh,
Thanks, Jennifer.
Correct.
great. Thank you. Next question. Certain tribes we have worked with are requiring us to send mail to them certified. So when we get those green cards back, what is the recommendation by DHS to do with those green cards?
I am assuming that they're talking about the Iqua notice here, but I'm not sure. It doesn't say what, but since we're talking about the Iqua notice, tribes are requiring that, I mean, the law requires that you send out certified registered mail to everyone. So that has to be done regardless of anything. Those green cards are often uploaded into MGA because the judge is gonna want to look and make sure that, you know, they're following Iqua, and in order to do that, they need to make sure that those green cards went out to the tribe, the parents, the Indian custodian, if there is one, and the BIA. So a lot of times people will upload those green cards they got back into MGA.
Yep.
That is best practice to upload it. That I have seen them sometimes in SSIS through Chronology. That's really rare, but it's common practice to put those in MGA.
So Carrie, another thing, I've gotten a few emails since our last session on Mifpa notice, and a couple of counties stated that tribes are requiring the county agency to send certified mail for both the Mifpa notice and the Iqua notice. And they just wanted clarification on why some of the tribes were requiring everything that's sent to them be certified. And I think that that's what this question might be alluding to.
Mifpa
I don't
notice
know.
is,
I think we answered that the last
Yeah.
time is state statute and federal law require, well, state statute require that you send the Mifpa notices out through fax or email, and then follow up with a phone call.
Okay.
just tell them it's the state law, it's what we have. That's what they have to follow. I mean, we're required to do that. So, and Iqua knows our federal law, we're required to send it certified mail. That's two main separate things right there.
So thank you. The next question. This isn't directly or specifically related to this topic, but is the correct term to use Indian or American Indian or Native American or other? I want to be respectful and correct.
Well, a lot of people go American Indian, but it's in our Iqua law. It's like Indian, so it has a legal status. So that's how if you read the Iqua law and stuff like that, it says Indian mainly. But a lot of people have different preferences. They're American
I think either one of those would be fine. And then when you get with the family, you might ask them what they want to be called, you know, just like you would in any other case. What do you identify? And then using that language.
I just want to make sure to put in a comment referring to other for Native American is not appropriate.
I didn't see that.
You-
Good
you
catch,
broke up.
Reanna.
Can you say that again, please?
She's frozen.
She said that referring to someone as other is not appropriate. You wouldn't want to refer to someone as other
Was the other? Oh, sure.
or something else. Okay, moving on.
So how many, thank you, next question. So how many times should we try to serve the parents? Is 2 or 3 times sufficient?
Is that the Equinox we're talking about? I take it.
Yes.
Should be at least 2 to 3 times, showing that you've done diligent efforts trying to reach out to find these families and stuff, and documenting that you've done your work. And then
Yeah,
Yeah,
I would say yes, it is. And it's really important to document your efforts, like Richie said, so that when we're, looking at cases, we could see all the attempts that were made to locate a parent. And showing the court that those attempts were made is really important too.
Thank you. Next question. If we've met with the family and had several discussions about having to notify the tribe and the benefits of having the tribe involved about voluntary mental health case management, and the family still refused to, and they still refuse to open services, if the tribe has to be notified, what should we do? I've had a few cases like this. Some families just simply refuse services. It seems like the child is being deprived of services then due to the parents' choices. Just more of a statement.
Well, I can imagine that would be really hard, but you're required by law to notify the tribe, and really maybe having a conversation with that family or that parent and asking them what is behind this, what is behind the fear, because and really explaining to them under Iqua, you have more protection under Iqua. The tribe might be able to help with financial resources, with cultural resources. Just, really having a conversation with them, which to get the bottom of what it is.
Yeah.
But you're obligated to notify the tribe. Unfortunately, that's
It's like when you're mandated reporters, you have to report. It's the law. We have to report things, do things.
or not unfortunately, but fortunately, because I think it's a positive thing, because the tribes are very helpful with that.
Yeah.
And if it goes further, if it goes into, if it should go further into out-of-home placement or child protection case management, then the tribe would already have that information and history to be able to help them with resources.
Thank you. Next question. An initial CHIPS was sent by certified mail to the tribe, parent, BIA, but not all children were on the original CHIPS. So the CHIPS was amended to include all children. Do we have to resend the amended CHIPS by certified mail again to all parties?
Well, if the children are from
Yes.
different tribes,
Yes, you would.
Yes, I would say yes.
Okay, thank you. Next question. If we send, where'd it go? If we send the notice prior to the CHIPS admit, deny, and we get no response from any tribe, do we send a notice again prior to TPR?
What?
we got to follow up on that one.
I'm not
Could
sure.
you read
Yeah.
that again? Where
Yep. If we send the notice prior to the CHIPS admit, deny, and we get no response from any tribe, do we send a notice again prior to TPR?
Well, if you're talking about the Iqua notice, you're required to send out an Iqua notice when permanency begins for a TPR. So you're required by law to do that. Also, you're documenting your active efforts that you've continuously reached out to the tribe, you've sent them updates on the case. All those are best practice in the SSIS chronology notes.
And I was wondering, like, did the tribe respond, or do you even know what tribe it was, or did you send to the BIA requesting for assistance? I mean, there's all kinds of things in that question.
Thank you. Next question. Can you explain what an Indian custodian is?
I can explain that. I can read it right from the Mifpa. It's an Indian person who has legal custody of an Indian child under tribal law or custom or under state law, or to whom temporary physical care, custody, and control has been transferred by the parent of the child. So it could be a situation where legal custody has been transferred to someone under Minnesota law or some other state, or under the tribe's laws or custom.
You know, are they taking care of this child? It's a gray area. Indian custodians. It could be someone that's taking care of the kids for like 2 months or something like that, and they'd be classified as Indian custodian. So
The parent has given permission to, like, say, a grandmother, here, can you take the kids, you know, and they have an agreement, and that grandmother has been raising the kids, she could be considered an Indian custodian.
It's probably a little less clear when it's done, you know, through tribal custom, but in the state law, it would be like an order giving somebody custody of a child. But if you're doing it under tribal custom, it's a little bit different.
Mainly, I've seen the Indian custodian only like it's a parent. I mean, like some relative is taking care of these children for such a time, and they've become Indian custodian. I've seen coming out of Hennepin County for those years and stuff like that.
But it is defined. It is defined in Mifpa. So if you need to look at the definition, it's under Mifpa, the statute.
Thank you. Next question. What do you do if bio dad and legal father are different? So for example, husband is not legal father and parents have not been together for years. Bio dad has the tribal affiliation, but legal father does not.
But that father is still the father of that child still. There's no termination, nothing like that. Even there was a termination, they still have Iqua notice. I guess I don't know what the whole case is going about, but
Yeah, if the biological father's rights have not been terminated, that father should still get notice.
Yep.
I mean, even if there's another person that has been, essentially maybe raising the child.
Yeah.
But the bio dad must get notice.
yeah, regardless, because we don't know how the dad is. Maybe that father, the legal one, maybe he's not doing well, and this bio dad is fine now.
So a follow up to that. So the bio dad may have given up his rights, and now the child has the legal father. Would the legal father get the Iqua notice along with bio dad, or I'm just following up the question.
If there's been, you mean like if there's been an adoption by
Yes.
a legal, like a step parent adoption or something like that?
Yeah, so maybe the legal father has signed the rights to parent this child, but he's not the bio dad. But there is a bio dad also. So would the legal father also get the Iqua notice?
If the legal father, if you're talking about like doing a step parent adoption, okay, where the bio father has given up his rights and another person has stepped in and adopted the child, absolutely. That father would get a notice.
So the follow-up that was listed to that first question is just husband is legal father.
Yeah.
I'm not quite sure what that means.
Even as
there's the bio father, and then there's maybe somebody who's taking care of the child and raising the child as their own.
Maybe it means that the parents were married and then they had this child, but that is not his biological child. He's the legal father. I don't know. It's too many ifs and whats.
Yeah.
It's not clear enough.
Probably need more information.
Okay, so thank you. Next question. Clarification. Last month, we were told that we need to keep sending Mifpa notices for every open case because sometimes we get more info or there are changes in qualifications. But now I just heard if we have been given one notice that says no, then we don't need to send anything else. That's
Okay, so if that
really-
case is open and you got something from a tribe saying that they are not eligible for membership enrollment in writing, that child is not covered under ICWA. Now, if that case closes and like say the next month it opens up again and you do a MIF, you have to again do the Mifpa notice. You have it again, it's an ICWA case. If they're saying, yep, I am affiliated with this tribe, you would have to start the process all over again.
Okay, thank you. Next question. So active efforts do not stop until written response from tribes stating that they are not eligible, or excuse me, eligible or enrolled. Sorry. So active efforts do not stop until written response from tribes stating that they are not enrolled or eligible for enrollment.
Yes,
Correct.
still ICWA case.
Correct. You keep providing active efforts until you get a written confirmation from the tribe that they're not eligible or enrolled.
Thank you. Next question. Carrie just mentioned that if the tribe says a child isn't eligible for enrollment before we do an out-of-home placement, then ICWA does not apply. However, we have seen cases where ICWA did not apply until the TPR petition was filed. Then certain tribes have said at that point, in that case, that the child is eligible for purposes of ICWA and does intervene in that case at that point. So should we keep notifying tribes formally with ICWA notices at each petition being filed just to be sure?
Well, the question right there is if the tribe is not going to intervene at that time, that's still an ICWA case. So that's the one thing I just want to point out. If they're not going to intervene, that's still ICWA case. Doesn't mean that you should not do active efforts to keep doing everything. Some tribes will say we're not going to intervene, so that's one thing. If they're saying, if you get a letter stating they're not ICWA eligible, they're not eligible for membership, then there would be a non-ICWA case that way. It needs to be
Yeah,
documented.
however, this could, with this case, with this question, it's really hard because what if the child wasn't eligible and you got something from the tribe saying they're not eligible? You're working with that family and then it goes to TPR. And then all of a sudden the tribe comes forward and says, hey, this child is eligible now. Then ICWA goes into effect. Anytime a tribe comes in and says, this child is eligible for membership enrollment, then it goes, ICWA and Mifpa go into effect. You would do your Mifpa notice, you would begin your ICWA notice, you would get the tribe, a QEW from the tribe, all the provisions would start applying to that case. We've had just a recent situation where Red Lake has changed their enrollment for membership or enrollment. They've changed it. So now some new kids are now eligible under ICWA. Maybe that's a good example of how a case that could have changed the course of a case when it comes to TPR. So a tribe has their right to intervene at that time.
Yeah, I know Red Lake back in the beginning, they weren't going to intervene during the CHIPS proceedings, but they were going to intervene if they're going to hit permanency. That was what they're doing. That was right back in the beginning like that.
So it's hard to answer these because we don't have the whole thing and I hate to make up scenarios, but that would just be an example of that. So, okay, next question.
Okay, thank you. Next question. If you are working a case in tandem with an ICW worker who has custody of the child, do you as the voluntary worker have to send out notices to the tribe of voluntary services as the tribe is the one who got you involved?
If you're we kind of talked about this before, like if the tribe has jurisdiction and the county is like doing some voluntary services with the tribe, I think they're saying, and you're entering an SSIS, right?
And they're financially responsible?
Yeah, and they're financially responsible.
That is something you would work out with the tribe. This is a great example of doing active effort. So you would sit down with the tribe and say, hey, who's going to do what? Let's agree on this. figure out and come to an agreement. So we wouldn't have anything to do with how you agree with the tribe to do those services for that
Yeah.
case.
And you could send out the Mifpa notice because you're entering SSIS, because they'll be in there, that information, but that's basically the only thing. But what Carrie said, work with that tribe.
Yeah, SSIS doesn't know whether doesn't have tables that communicate to each other that know whether it's a voluntary or involuntary case. So it's going to flag you and give you data cleanup if you're not entering these notices or information on the screens. So I would say best practice would be to fulfill the requirements in SSIS and document in chronology case notes all of your efforts with the tribe.
But making sure, more importantly, that you sit down with the tribe and come to those agreements of what you're going to do on the case.
Okay, thank you. Let's see, 11:20. Next question. I'm a children's mental health worker. I know that we send out Mifpa notices to the tribe when we open a voluntary case. However, I did not know that a voluntary placement agreement needed to be signed in front of a judge. We don't have a court review until day 180. What is the process that we ask for a judge's time if there is no court case open?
I would recommend you talk to your supervisor or your county attorney and ask them how they want to handle that case, because it is required by law that a voluntary placement is signed in front of a judge.
Mhm.
Next question.
Thank you. Let's see. So say the child was with grandparent by parents, and then CP gets involved and continues the placement, but it is now a foster care placement. Would that be an Indian custodian?
It could be, but if it's a voluntary placement, that's usually the way they want to go, because there's more benefits to be, foster Indian custodians. You don't get any money for helping these children and stuff like that. So, I mean, if they're licensable, it's always best to go through the license that way. And the tribe will determine that too. The tribe will step in on that too, for Indian custodian.
All right, thank you. Next question. And I think this might be the last question. I don't know. Do HIPAA laws apply to Iqua cases? How do we contact providers and other extended family without ROIs to inquire about Native American heritage? How do we explain who we are and why we want the information we are asking for without an ROI? I was under the impression that we cannot even acknowledge we are working with someone without an ROI under HIPAA.
Eric, do you have that, the language that covers about doing inquiry with other family members?
I don't have ready access to it,
Okay.
but I do know that we discussed that to do Iqua inquiry with mother, father, and reaching out to the tribes, that does not require a release of information. And you are required under law to reach out to the tribe, whether the family wants tribal intervention or not.
Right.
But when we're talking about releasing case-specific information to relatives, that's where we get into kind of HIPAA law and releasing information and so on and so forth. So for HIPAA related purposes, you don't need a release of information to inquire about Indian heritage. However, if you're going to release any case-specific information, see, I don't know, maybe I should stop myself. Case specific, like if you're going to get into the details of the case, that's when you need to use discretion and consult your county attorney.
Yeah,
that's right. That's right.
but if you're thinking like a family member is American Indian, or you think this is, and they're involved in the case, then you should be asking them. Yeah,
You should be reaching out if you have their information, and you should be reaching out and inquiring about American Indian heritage.
Yeah, that's all you're doing.
Thank you. Next question, who is the best person to contact at DHS for Iqua guidance on a case? to ensure we're doing all aspects correctly?
Well, we do recommend that you're using your case, all the tools that are provided to you on the DHS website. Because it's, obviously good if you know what Mifpa law is and Iqua law is. So using the desk aid, using the caseworker checklist, a lot of times those will answer the questions that you have if you're reading and using those tools. And then if that doesn't work, then you could reach out to our CRM, which is an email address that you send in and ask questions. We each take turns answering those weekly, and then we get back, get back to you with an answer. But unfortunately, we don't have time to monitor everyone to see if they're doing everything correctly. So it's about learning and stepping out and using those tools.
All right, thank you. I think we have time for one last question. And it was related to, it's a follow-up question regarding the ROI. So you are allowed to release that you work with the child and say their name without a release of information. That is news to me.
That is correct. You are allowed to call them and do inquiry with other family members, with aunties, with schools. You are allowed to do that as long as you're not exchanging information about their cases. So I'm glad we have this question. Now it's out there, and yes, you can call other relatives for inquiry.
That's a true social worker answer, Carrie. Good job.
All right, it is 11.